All right, everybody, on behalf of Trident Title, Performance Title, and Synergy Title, I want to welcome you guys back to Better Call Paul. Today, we're talking about deeds, as this question has came up a lot. A lot of people have been talking about it and wanted to know what's going on. And usually, whenever the market gets crazier, people start talking about quitclaim deeds. It seems more and crazy stuff going on in the world. So I wanted to get Paul on here and talk about this a little bit. From what I understand, Paul, and hopefully you'll spread some light on this, there's really 4 different kinds of deeds, but 2 of them are what are used most often. So elaborate on that as much as you want and tell us what we need to know, and then we'll leave it open for questions.
Okay. I'm not sure what the 4 different types of deeds are. I can count a general warranty deed or a statutory warranty deed is one type of deed. A special warranty deed is a different type of deed. A quitclaim deed is a third type of deed. And then there are other types of conveyance documents, a personal representative's deed, a trustee's deed, and
we had someone ask the other day about a fee simple deed, and I had never even heard of that.
Yeah, I was going to get to another one, which is a life estate deed. And there are 2 types of life estate deeds. And then there are homestead devises, which are actually court orders and not a deed at all. So we can go through each one of them and
whatever you think comes up the most. I know, we don't use all those every day, but definitely would be good to get a quick summary of them.
Okay. You want me to go from the back to the forward? The ones that are used least?
Yeah, least popular to most popular.
Good. Least popular to most popular. When somebody dies and it's their homestead and it's going to be devised to their spouse or children, that's an order from a judge that gets recorded that says this is deemed homestead property and the beneficiaries and existing owners are blank, blank, and blank. So there may not even be a deed that's delivered in that circumstance, but that conveys the property for homestead. Then there's a personal representative's deed, which is when you're selling non-homestead property in an estate, the personal representative signs that deed to transfer the property to the third party. Similarly, if the property is owned in trust, somebody passes away, the successor trustee steps in, you record a trust affidavit, and you transfer the property via that trust. Another less used vehicle is a life estate deed. That's when you transfer something other than a fee simple interest to somebody. You transfer them the right to live there for their life, which is why it's called the life estate deed. And then you identify who the remainders are when that life estate holder passes away. So and
you
that
see any of these that, like these first couple, like, do you see these regularly, or is this like a once in a blue moon kind of thing?
No, I see them every week. But that's because people are struggling and need to come to me for help with something, not because they're regularly used in commerce. Most deeds that you're going to see are a general warranty deed, also referred to as a fee simple deed or a statutory warranty deed. And that's where the seller warrants that they have good title and promises to defend title against anybody whomsoever.
Got it.
That's the language you see at the bottom of the deed. That's why it's called a general warranty deed or a statutory warranty deed. That's number 1 most common. Second most common is a quitclaim deed, where people are asked to transfer whatever rights they have in a property to clear up some title issue. So if you're the surviving heir of your great grandfather who didn't properly sign a deed, they might track you down and say, "Oh, look, we just need a quitclaim deed. We're not asking you to say that you own it. We're not asking you to warrant anything. We just want to clear up title, and we think we have to get a signature from you and record it." So that's a quitclaim deed.
So what are some of the common issues with quitclaim deeds? Because I know a lot of times it seems like it comes up in the investor world, especially like in the wholesale kind of thing, where they'll say, we have something under contract, has to be a quitclaim deed. Does the new buyer really have that much to worry about? Is it something that they can get taken care of, with someone like you clearing it?
It really depends if you're getting title or not. If you're getting title and there's a title company that's promising you own what you own, it's okay to accept it that way. But if you're not, then I would be concerned.
So in the example, let's say a flipper, they are, purchasing a property and with quitclaim deed, and then the plan is that, in the next 60, 90, 120 days, they're going to go sell it. Is the process different for them or much more difficult if they want to then transfer as a warranty deed? Or, can they be working behind the scenes to clear issues throughout those 30, 60, 90 days, that they hold for to make it? Or what do you see when things like that happen?
So one of the times that people use quitclaim deeds is when they bought a tax deed and they don't get clear title unless they either file a quiet title action and serve everybody that should have been served in the auction, or if they go to a service like Clear to Sell, where in 60 days you get it certified and cleaned up so that you can issue a warranty deed. The general concept is that quitclaim deeds are for discounts. You're giving a discount because I'm not warranting title and you've got to figure it out for yourself. And you might have to deal with county, city, IRS, everything else. And that's that's something that you're going to have to factor in when you agree to a specific price.
So you mentioned Clear to Sell earlier, and I know we weren't turning this into a Clear to Sell class, but I know that's the service that you guys offer. And you also mentioned 60 days. Is that a normal time frame, and what kind of succession rate do you have with that? Is it a slam dunk, or is it 95%? Or I know you've done a lot of them. What do you see?
Yeah, it's funny. We just recalculate every quarter. We look and see what our certification rate was for the last quarter, and we stayed pretty solid. Between 94 and 95% of our files have been certified in the last quarter. So if you do buy a tax deed or have a client who bought a tax deed and intends to transfer to a third party, if you sell it via quitclaim deed, Ryan's correct. You have to give a substantial discount because people factor in that there are title issues and they're going to have to deal with them. But if you come to Clear to Sell, we charge a $900 research fee, and within 20 business days, which is basically 30 calendar days, we can determine whether we can certify that property or not. And if we can certify the property, you can get a clear title policy from any title underwriter in the state.
So in something like that, when it's an investor deal, because usually they don't have 20 days to wait, or 30 days to wait when they're trying to lock it up, do you recommend that they get it and, try to put the deal together, get the property, send it to you, start it as quick as they can? Or is this something where you're looking at and saying, okay, I want to buy this in 30 days. I'm going to give you $900, gamble on that and hope that, you can make it work and then decide if I want to buy it? Or, with 95% success, that seems pretty good, obviously.
Yeah, that's right. Most of our investors are pulling the trigger like this, and they know that, for the 5% of the time that we can't certify, that we'll just do a quiet title action, and that'll take 6 months instead of 60 days.
Got it.
To be able to sell. So on that one, they have to hold their money for a little bit longer, but all the others, they're flipping quick.
Got it. Makes sense. Abby said she has a question. Abby, go ahead. Just unmute yourself. You're still muted, Ab.
Sorry.
There you go.
Hey, Abby. How are you doing?
So what's the difference to me as I'm representing a buyer if they're going to receive a special warranty deed rather than a warranty deed?
Yeah, a special warranty deed promises to defend title for anybody who makes a claim about something that happened during your ownership.
During my buyer's ownership or during the previous?
during the seller's ownership. So the seller says, I'm offering you a special warranty deed. That means I don't know what happened before me, but I'm
Ooh,
promising you I didn't do anything to this title.
wow.
Got it.
So
So
that's not very good, but I know that like back in the day, that's how all of the banks gave us title
correct.
on short sales.
Yes.
And we were really, I guess, lucky if no issues came up.
Well, don't think of it that way. The reality is you're getting title insurance from an underwriter.
Okay.
And I always tell my clients, I don't care what the seller warrants. It's nice to be able to file suit against a seller, but eventually, especially if it's a big number, they'll just file bankruptcy on you. You won't collect against them. The guy I care about is the title underwriter.
Right.
And that's why I don't like to use the I don't want to use a negative word, but the lesser title underwriters that you see today, the 15 or so that are in the marketplace that have no
Mhm.
capitalization, no reinsurance, no backing. And if there's a major problem and everybody files a claim, they're going to be out of business.
Okay, that was great, and that answers that question. Then I have another question. Can I go ahead, Ryan?
Yeah, good. Yep.
Okay, so I have buyers, husband and wife, and they want to purchase a property, and they say, we want to put it in the type of deed that, and I guess is the probate issue, that if one of us passes, the other one gets the property. I say that happens automatically.
If they put it, are they married?
Married.
Okay, you just put it in both of their names and put the words as husband and wife afterwards.
What if
And
the
that
as husband
automatically
and wife is not there?
Excuse me?
What if the as husband and wife is not there?
It's presumed under Florida law that if they're married at the time they take title and they don't specify that it is presumed by tenants by the entireties, but you should put it in.
Okay, and then the last question is, let's say that the buyer has a trust and they purchase a piece of property. How do I know how to title the property? Do I put it in the trust? Do I have to hire an attorney to do that? Do I just put it in the person's name? And then after they purchase it, they take the property and put it in the trust? What happens?
Yeah. So those are the kind of questions that I don't think a realtor should answer. You know, if a client says to you, I want to take title in the trust, you say, I'm not an estate planning attorney. I don't know.
That's what I have been doing.
Yeah.
But I personally have a trust. And from
Okay.
my personal knowledge, I wanted to know if my homesteaded property needs to be put into that trust, because the trust was enacted before I purchased the property.
So people use trusts for two reasons. One is they don't want to have their property in their individual name and they'd rather have it in a trust, generally for probate avoidance. And two, because they're still they don't want it individually and they want to qualify for homestead. So if you have a revocable trust and you want to avoid probate and you want to still qualify for homestead, you could use the revocable trust to be the holding entity.
Cool.
Okay, when they change the deed at the property appraiser by quitclaim from, let's say, Abby Konigsberg to Abby Konigsberg's trust, do they reappraise it like they do it for a sale? Will the property tax change?
They don't.
Okay.
I don't know why you would do it by quitclaim deed as opposed to warranty deed.
Okay,
Whenever you use a quitclaim deed, whatever title insurance is vested in you is lost when you do a
Oh.
quitclaim deed to the trust.
oh,
So I would do that via warranty deed so that you have the best chance that if there is a title claim, you can argue that your rights have
It's the same.
continued with that revocable trust.
okay, all right. Thank you, Paul.
Yeah, of course.
Francis, also, I saw a question in the chat. I'm not really understanding what you are asking. If you would like to unmute and jump on, you can do that.
Hi, I'm sorry. Mine was more of a commentary to what Paul was saying. The
Okay.
only quit claim deed I've seen is I've had clients that were divorced and one quit claimed the deed to the other.
Yep.
And
That's a very, very common use of the quitclaim deed.
so the point is just to get it out of one person's name into another? Is that
Yes,
it's like it sounds? Okay,
correct.
that's a little different from what I thought I heard you saying, but that must be another.
So with an issue like that, if there's a mortgage on the property, Paul, what arises issue-wise with that? So in her example, husband and wife get, they have a property and they still owe whatever, 50% on it. And then they quit claim it to get them to one of them.
Yep.
What-
There's a specific statute that that has governance there that says that they can quit claim between themselves incident to a divorce, and there's no documentary stamp tax due. There's nothing due.
No due on sale or anything like that to pay
Correct.
the mortgage. Got it.
The statute overrides.
Got it. Awesome.
Okay, thank you. Like I said, it was more of a commentary to what he was saying, but I got
Sure.
it now.
Yeah,
Thank
no, that was a good point though, because I'm sure other people have something like that. Thanks, Francis.
Thanks.
Anybody else with any questions? And I guess the other thing too that I just wanted to point out is like when you were saying earlier about the underwriter, if you're closing with any of our offices at Trident Performance or Synergy, you have Fidelity National underwriting that. So if we close it, you have the backing of I think $13 billion company covering that versus, like Paul said, in some cases, who knows if the money is going to be there to cover, where I'm sure you know the numbers better than I do, but I know there's a huge fund available just for title insurance claims, right, Paul, with Fidelity? And that was one of the reasons you guys chose Fidelity in your sale.
Yeah. The cash on hand that Fidelity holds is greater than the top 3 other title underwriters combined. And, look, we're not insuring power plants, so there's not really a chance that we're gonna tip that fund.
Yeah.
But if some of these underwriters did take a piece of an insurance of a power plant and there was a mistake, I think they could go out of business. It's not a huge deal, but it's something to consider when you're trying to decide who you're going to use as an underwriter, because the truth is that seller is gone.
Yeah.
That seller gets your money and they're moving back to New York or California or even down the street, but they're going to put that money in a new homestead. You're not going to be able to get that money. If they lied to you about everything and you get a judgment, you could take that judgment, stick it on the wall and throw darts at it, but you're not going to collect on it.
And like you said in the past too, that's when there's even easy ones. I know you've said you've tracked people down across, into different countries trying to get these things rectified. So it's a whole different world there. Tracy, I saw you unmuted. Do you have a question?
Well, hey everyone, and hello, Paul. It's a pleasure to meet you. I needed to talk to you as well about something else, but situation. If you have a seller, parent died, left the seller as the administrator, administrator never did a quick claim deed because parent died, but she wants to sell the home. How can she do that, or how does that work?
Is the probate still open?
No.
You'd have to open a probate and you'd have to appoint a personal representative and have a sale.
The seller is the daughter. So the daughter would have to open up another probate.
Correct.
Okay.
You say another probate, was there one done already?
I don't know. She started mentioning that she was thinking about doing it. years ago, but she didn't finish it. So
Well,
that's why I
If it was
indicated another.
open, if it was open, you could reopen it. If it wasn't open, you'd have to start a new one. But you absolutely have to get a court order in that circumstance to appoint somebody to sell the property.
Okay, got you.
And we do that all the time, by the way. Just got a referral from KW Welling today, and we're well on the way to getting it opened and started. And these are the kind of things where you need somebody who's going to be pushing.
Okay, all right, got you. Thank you.
So just someone asked in the chat, and I just wanted to kind of let everybody know too, if any of these complicated issues come up, someone asked if you're an attorney, a CPA, or both. So explain that, I guess, on where your line is on that, and then I'll type in the chat for them how to get in touch with you.
Yeah, I'm sure. I am not a CPA. I think I understand the tax ramifications of all these issues just from having dealt with them for 30 years, but I'm not a CPA. And when I have questions, I reach out to CPAs to get answers for you. I'm a real estate and estate probate attorney, but I am.
And just so you guys know, Paul is involved in all of our title companies, so Trident, Performance, and Synergy. So whenever, that's why we do these kind of on behalf of them. So whenever you're using one of our title companies, I mean, Paul has a huge staff as well that usually takes care of these things before they reach him. However, he's involved in all these. So if there's any issues that come up along, you always have access through Performance, Synergy, and Trident to Paul to be able to kind of rectify these things. Paul, what's the best email for you too, so I can just type it in the chat for them?
pkrasker@kraskerlaw.com.
All right. Anybody else? Any questions? I typed his email in the chat if you do have something interesting that pops up and want to reach out. Any questions before we let Paul go? If you guys have not already booked Monday at 11 on your calendar, we are doing how to generate listings in a low inventory market. So make sure you're here for that. And we have every Thursday at 4 o'clock planned out already for topics with Paul. Next week, we are doing furniture, personal property, all those issues that come up, you know, like right before closing and all those issues. And if you have anything, I know we're gonna have fun with that one. And if you have anything for Paul, feel free to reach out. I did throw his email in the chat. Thank you guys again.
Brian, before we let Paul go, this is a learning curve for all of us because no one in our office could answer. If you have a situation where you have a seller who's selling, but the HOA denies the seller, but does not give a reason for the denial, and the seller hires an attorney, how does that impact the agents?
Not sure I'm following the question. What, the HOA denies the seller to be able to sell the property?
Denied the owner, denied the buyer from being cleared, but did not provide a reason. The only thing that they said was that all the boxes didn't check off. But according to speaking with the people on the other side, there is nothing in the bylaws that was specific to why the buyer was denied. Paul.
Yeah, so seller certainly has the right to inquire, and the association has an obligation to provide the reasons why they rejected them. And if the seller wants to pursue that, they do have 30 days to treat that as a title defect under paragraph 18A of the contract, at which time the buyer has a right to walk away if they're not approved.
But if the seller is already under contract and the buyer wants the property, where does the seller fall in all of that?
Again, they have a 30-day time period in which they can try to cure the non-approval. And after that time period, it's up to the buyer to either extend that for up to 120 days additionally, or buyer can walk away.
Yeah, Tracy, without that approval, that, you know, the title won't be able to close them. So if there's no approval, you know, the deal is either dead instantly or, like Paul said, 30 days.
Gotcha.
So you could try to fight that, but I mean, we did have an HOA attorney on here actually once that we could connect you with if you want. It was probably a year ago now, but she was really great. So we can connect with that if you want. But I would imagine if they're not approving that, that's usually pretty much it, right, Paul? I mean, whatever reason.
Yeah, I mean, they usually do it because the credit score is too low and they're worried about getting their payments on a regular basis or something of that sort.
Background check a lot of times is a
Yeah,
key.
exactly.
Yeah. All right, guys. Thank you again. Good to see everybody. Have a great holiday. If you are celebrating anything this weekend, Paul, thanks as always. And I will see everybody next week, Monday and Thursday. See you guys.